Hi, folks. I'm Denise Howell, and you're about to join us on This Week in Law. My co-host Mike Keys is here, as well as Matt Erickson from the Digital Privacy Alliance. We're going to talk about accepting a TOS and agreeing to paint a snail, what to expect when you're expecting on the net, updating ECPA, and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, Matt Curtis, and Mike Keys. Episode 394, recorded August 4th, 2017, covering your bot. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. Hey, we've been on break for the summer. Not the entire summer, but the last couple of weeks of the summer. I've been doing some fishing, some actual fishing with actual fish. And I'm not sure what Matt and Mike have been up to, but we'll find out what they've been doing. We hope you've been having a good time. A nice break for the last couple of weeks. But at the top of the show here, we should probably disclose that although our show is called This Week in Law, where we talk about everything interesting at the intersection of technology and law, because we've been off for a couple of weeks, you may find some stories that have been about the last couple of weeks that we just haven't had the chance to talk about yet that are pretty interesting to us. So we hope they're interesting to you too. We've got a great panel of folks joining us today to discuss such things. Mike Keys, my co-host, is here. Hello, Mike.
Hello, Denise. Great to see you. Great to be back. And welcome back from your own private Idaho. I was spending some time in Idaho myself, so
you were there.
It's quite a place.
Did we cross paths in Idaho at the same time?
I don't think so.
We did.
You were in southern Idaho. I was in northern Idaho. I spent some time on Lake Coeur d'Alene.
Oh, how nice. Yeah, it was just beautiful where we were. I hope you had a great time too.
We did. Loved it. Great to be back.
Great to see you again. Matt Curtis, my other co-host, will be hopefully joining us later in the show. He's taking care of some business right now. We're hoping to see him pop up on Skype so that we can add him in so that he too can meet our wonderful guest this week, Matt Erickson. Matt is Vice President of Engineering at Spider Oak and the Director of Industry Outreach at the Digital Privacy Alliance. Hi, Matt. Great to meet you.
Hi, great to meet you and great to be here.
So before we jump into our show, and we've got lots to talk about this week, maybe you could tell us a little bit more about both of the hats that you wear. Tell us about Spider Oak a bit.
Okay, so Spider Oak is a 10-year-old company. We specialize in secure and private online collaboration tools and file backup. So if you have data that you want trusted, or if you have data that you want to communicate or share with anybody, Spider Oak provides tools to be able to easily do that.
That's wonderful. And then it makes a lot of sense, too, that you're involved in the Digital Privacy Alliance. Tell us about that.
Mm-hmm. So the Digital Privacy Alliance is an organization that is trying to push for common sense, simple, straightforward privacy legislation in state houses across the United States. We're not looking to end any sort of major industry practices on the surface. We're just trying to make sure, for example, marketing concerns and things like that are done explicitly and consensually.
Right, and you were saying before we went live on the show here, not to make you be a lawyer. We're not going to make you be a lawyer here today because you're not one. Right. So we promise not to do that. But you're definitely involved in a field and in an advocacy organization that impacts legislation and policy and the law. That's a big project that the Digital Privacy Alliance has undertaken to advocate on the local state level for privacy laws. Big because we've got a lot of states, and big because they don't always want to do things the same way. How do you manage that?
Honestly, the answer is a little slowly. Definitely, we don't want to bite off more than we can chew. It really comes down to educating lawmakers and helping them understand the issues and all of the ins and outs of the proposed policies. And that just requires care, and it requires a little bit of time and just attention. So right now we're focused on Illinois. We're focused on Texas. We've got some great friends that we've made in Texas that have been working there. And we're working on expanding out from there.
That's great. Do you find yourself doing a lot of education at the state level, telling, for example, lawmakers in Illinois, hey, the state of New Jersey has already grappled with this, and here are some of the issues they thought about and how they decided to handle it? Is it sort of a getting people on the same page project sometimes?
A little bit. Honestly, one of the great things about being in Illinois is that our lawmakers are kind of leading the way here. So in the privacy realm, Illinois already has the nation's strongest biometric privacy law, the Biometric Information Privacy Act, or BIPA, which guarantees opt-in consent for things like facial photographs and DNA, fingerprints, biometric information. And we're looking to just kind of have that opt-in privacy for other sensitive data about who you are and what you are and where you are. So we have lawmakers that understand this. Everyone, for example, the Cook County Sheriff Tom Dart, Senator Mike Hastings, Representative Art Turner, Representative Ann Williams, they all really understand just kind of in their hearts what it means to have privacy in this digital age. And so it's not so much what we see New Jersey or New York or California. It's we see what isn't there, and they're looking to us to really see what's going on in the realm of privacy. Well,
that's great. That's refreshing and wonderful that you're dealing with lawmakers who know their way around digital devices and what they can do with your data. I congratulate you on that. Hope that the rest of the world follows suit. On that note, let's jump into some privacy stories, shall we?
Okay.
So one thing that we talked about before we took our little hiatus here on the show is this strange program that Google announced back in May, where they are pursuing the Holy Grail and claim to have attained the Holy Grail of online advertising. The Grail for the advertisers themselves is to know if they have shown someone an online ad, can someone demonstrate that online ad affected a buyer's psyche so much that they walked into an offline store and actually made a purchase. And Google is claiming to have tech in place that can accomplish this. It's not, however, being very transparent or forthcoming about how it is managing that system, and it cites confidentiality agreements with its vendors, et cetera, for why it's not able to tell the world very much about how this all works. But that isn't enough for Epic, which has gone ahead and filed a complaint with the FTC. Epic is the Electronic Privacy Information Council, if I'm getting their acronym correct. I think I am. So they've gone ahead and filed with the FTC, asking that the FTC look at this more closely, asking that the FTC investigate methodologies, push back on how things are being encrypted, how things are being managed, et cetera, which basically all Google has done at this point is come out and said, we can accomplish this for you. We're just not going to tell you exactly how we're accomplishing that. And Epic doesn't think that's quite enough. Particularly, I think this is a good story to discuss against the backdrop of another ongoing issue that we talk about a lot on the show. And that is this issue that anonymized data is not as anonymized as lots of people would like you to believe. That is demonstrated over and over again. We try and highlight stories where people have gotten access to databases of supposedly anonymized data and matched up that data with actual individuals. And that's something that just happened as well. DEF CON is something that went on while we were off on our hiatus, exploring the far reaches of Idaho and elsewhere. And one of the things presented at DEF CON was a journalist named Svea Eckart and a data scientist named Andreas Dews, who, again, it's just another example of people who've gotten their hands on supposedly anonymized data and shown exactly how they were able to match up data sets that were supposedly anonymized with actual physical human beings in the world. So if you want to read more about that, The Guardian has a great story detailing exactly what they found and how they found it, the tools that they use to de-anonymize the data. If you want to go deeper into that, I encourage you to look at all the sources that we've looked at to prep this show. You can either go to our Flipboard magazine for the show. Find me, I'm at D Howell on Flipboard, or we aggregate all the links for each show at tagpacker.com/user/thisweekinlaw. This is episode 394. So, Matt, against the backdrop of, the constant demonstrating that anonymized data is not as anonymous as people think it is, what do you think about Google's program and the fact that Epic would like them to be more forthcoming about it?
Honestly, I find it quite troubling. Anytime you have a mass amount of data, that mass data set has value. We can see even just election records being hacked. The more you collect, the more there is. And the fact that Google is not really being forthcoming as to how it's collecting this data, where the data is coming from, that's troubling. I understand that Google does have a rather solid security track record, which is a plus in its favor, but that's really the only one they have here. There's no way to opt out of this data with data collection and data use without essentially opting out of all Google services. And there's no clear idea as to how they get this data or who gets to use this data or anything else along those lines. There's no transparency, there's no consent, and really no idea beyond, as you said, Google saying that they can do this.
Right, and I think it was news to people. It's certainly something we scratched our heads about the first time we talked about it on the show, that Google could just go out and obtain access to credit and debit card records of 70% of U.S. consumers. But then Google assures people, but we've developed a mathematical formula. We're going to anonymize and encrypt the data. And then we're going to match it up with the transactions and provide it to our advertising partners. So Epic is pushing back on the fact that Google did not disclose the mathematics behind all this and how exactly the protection is working. But the fact that you can just go out and buy data sets like this is somewhat eye-opening as well. And again, the story of these German researchers who presented at DEF CON is pretty interesting too, because they didn't even bother to buy the data. Instead, what they did, just creatively enough, and because it would probably delight the crowd at DEF CON, they set up a fake marketing company. They put up a website. It looked very real. They even had a, we're hiring page where they started to get applications from people who wanted to work for the fake website. And so they put a public-facing front on their research that said, hey, we're in the business of crunching data. And then they reached out to people who let them, to data brokers, who said and told them, hey, we've got this AI advertising platform that we're developing. Why don't you help us out and give us some data so we can test it? And they did. So they didn't even have to buy the data in this instance, which just sort of adds a chuckle to the whole scenario. And some fear, because again, it's not that hard to gain access to these supposedly anonymized databases of information. Were you surprised to read about this at all, Matt?
Not at all. There, like you mentioned, there's a long history of anonymizing data. several years ago, AOL released a bunch of search results that they'd processed. Just searches that they had apparently tried to anonymize, but just what people were searching for was enough to rather reliably de-anonymize them. And any other data that can be connected in, it makes it almost trivial to today's basically hacker, computer scientists, data scientists to really put together large data sets on people that companies are releasing. And like you said, it's free. And honestly, this data has value. So even if you had to pay for it, there's a lot of cases where I can see somebody laundering some money through and just buying for access to the database. And then you get a lot of issues like security questions that you answer properly with like childhood best friend. There you go. Things like that can be connected in.
Sorry, I just checked in on the IRC, and Reverb Mike is asking whether holding yourself out like that as a false company and then tricking people into giving you data, would that be legally problematic? He's mentioning the term wire fraud. I suppose it could be, but here where they're doing research and publishing their results and doing journalism, they may have some cover from that. Again, they were in Germany, so I'm not quite sure, how their laws might differ from ours on that front. Mike, what do you think of all this?
Yeah, I mean, I read the Google complaint, and it is kind of astounding and very interesting. I thought, Matt, to the extent maybe you could help break down a couple of the allegations that are made here to help our listeners understand what's going on. So I'm looking specifically at the complaint that was filed with the FTC. Paragraph 10 alleges that Google collects credit card transaction information from direct import of customer data by advertising clients through third-party relationships, which capture approximately 70% of credit card and debit card transactions in the U.S. So it sounds like the first step is Google is partnering with the companies that place ads with it, and then looking at or scraping that all of the consumer transactions with those companies. Is that right? Does that make sense as to what they're doing initially there?
Yeah, that sounds about right. They might have. I haven't seen the direct complaint, so I can't speak directly to that. But Google has a lot of merchant relationships. Google Wallet lets you pay for things. That's an easy way into credit card information right there. If you're using Google Wallet, Android Pay, Google by nature at that point has a record of everything you've bought with a credit card, at least through that service. So they might be expanding access out through that to merchants.
Right. So even if Google itself doesn't have access to your transactions, it partners with advertisers and other companies that do have access to that information. And then they're able to use that information, see what you've clicked through online or on your phone, I guess, and then are able to somehow still marry that information up with an in-store transaction that the consumer made, right?
Yeah. And that's if it's connected cleverly enough, I don't see that being extremely difficult, as long as you had all the data in front of you, and it sounds like Google does.
Right, and I don't think you even need to have clicked on an ad. I think they can tell if you've been shown the ad, and then whether you've acted on simply having had it be in your consciousness or subconsciousness, your peripheral vision maybe.
Because the thing to think about with ads is it's not so much clicking on an ad that matters. What somebody wants you to do is to see an ad and then buy a thing. So as long as you can see the ad in today's modern tracking systems, they know if the ad has been visible to you as you browse a page. And then if they can connect that with a real physical purchase, they don't need any other sort of linkages.
Wow.
So one of the things that the Digital Privacy Alliance pays a lot of attention to, Matt, and we're thrilled to see you paying attention to this, is all of the devices in our lives and the data that they are sucking up. Apart from just our web browsers things like, for example, our household cleaning appliances. One of the things that broke while we were off for a couple of weeks was the Roomba story about the iRobot Roombas possibly selling mapping data of your home that they generate so that the home can be cleaned. Roomba's CEO and PR people went rapidly into damage control mode and came out and said, no, we're not doing that. We're not going to do that. But there's a good piece at Gizmodo pushing back on that and trying to figure out, if what's being said is matching up with the actual terms of use, et cetera, that are governing these things. iRobot still says it's considering sharing the map data. They just won't sell it for cash, Gizmodo reports. And there's really no way to guarantee that they would never sell your data for cash, despite what they're saying now. The other thing that bears noting is that the terms of service remain the same as they were. The terms that gave rise to the fact that this was a possibility, they haven't been altered yet. So even though there's been a lot of journalism around this, a lot of public outcry, a lot of people rolling their eyes about whether the map data to their home should be available or who the heck would want that anyway. The fact is the terms of service remain the same and seem to leave the option open to sell off the assets of the company to third parties, including the mapping data generated by the Roomba. So just a good cautionary note for people as you're considering these stories to definitely hold the executives of companies like this accountable for what they say and dig deeper into the actual terms that govern the company's relationship with you. What did you think about the Roomba story, Matt?
Well, first off, seeing that the CEO is just kind of promising into the ether, it's not really worth the paper it's printed on. And it's not printed on anything. So unless the terms of service change, we at the DPA really are kind of not really holding very much positive views on this. And promising not to sell, so they may share data with somebody and not receive a direct check for that data that they share, but there's ways to make compensation work, even if the data is shared for free.
Right. It's like the German researchers. Maybe there's some reason why Roomba would want to give the data away in exchange for something that it gets back. Yeah,
and there could be, for example, tying back to Google. Google is the world's largest online marketing agency. They may share data and get a lot of free advertising. They're not selling the data. They just happen to gift it, and they might happen to get a lot of free advertising or reduced rates. There's a lot of very intimate information about your home that is being shared online, even down to where your furniture is, pets that you might have, when you're home, when you're not. It's a little scary.
So when we're talking about mapping data of a home, what's included? I know you just had a laundry list there, but are we talking about actual video or audio here, or is it just kind of a schematic that would be shared? Or do we know for sure?
Well, unless Roombas have changed since I last looked into them myself, I don't believe they have video or microphones, but they do make quite detailed maps of your home. We're looking at everything like furniture layouts. They're making this data so that the Roombas can actually do better cleaning of the home, run around the house, and not spend more time vacuuming and less time running into walls, which is a good win. But if they notice you have large empty spaces in areas that look like dining rooms, you might start seeing ads for dining room sets. And on the surface, okay, so you might have a big empty space and you might be looking for furniture and you might start seeing ads for furniture sales. On the surface, that's cool. And honestly, at the Digital Privacy Alliance, that level is everyone wins when you have metrics-based advertising that is explicit and consensual with the use of data. The problem that we have with this, just like the Google story, is there's no transparency as to who gets this data. There's no security as to who gets this data. You might, like burglars are us, might simply start getting home schematics. So they don't have to worry about breaking into your home and then finding where things are in your home. They know how your home is laid out. They know where the furniture is. They know where a dresser that might have your watch collection is. So they just bust in, grab, get out before the police can come, before the alarm system can ring. And that's the sort of controls on the data that really make this a fearful proposition.
Hey, Matt, the Gizmodo piece actually talks about some of the Roombas having onboard cameras.
Okay.
And they asked iRobot about that, and were specifically told that any of the units that have onboard cameras, those cameras are physically separated from any wireless or wired transmission. And the only data that is sent from the robot to the network with customer consent is information about cleaning jobs and lifetime cleaning statistics. Gizmodo goes on to comment, of course, just about anything a camera-enabled vacuum records while patrolling your home for dust bunnies could be considered information about cleaning jobs. So it's a pretty broad cover that they've given themselves there in their terms of service. And we're not going to make you be a lawyer, Matt, but we are. And one of the things that occurred to me in thinking about this, Mike, is we've got the CEO, Colin Angle, I think is his name. Yeah, Colin Angle, saying one thing and management and PR scrambling to assure people that their cute little iRobots are just benign things that their cat can ride around on and their dog can bark at. But maybe the lawyers, it seems like the language in these terms of service is pretty standard here, and it's something that a lawyer would do to protect the company's options, which is often what lawyers do, even if they haven't been given specific direction from above. They just put together some terms that say, okay, we're just going to be broad here and make sure that we're not taking anything off the table. And perhaps that's what happened. And now they just need to really go back and review to make sure that company policy is actually getting implemented in these terms of service. Do you agree it's sort of a right hand not knowing what left hand is doing kind of thing?
I totally agree with that. And you could envision a scenario whereby these terms of service say something to the effect of, this is the complete agreement between the parties and no other oral or other representations are binding. The terms of service are the agreement between the companies. So statements made by a CEO or another representative, an oral statement made to the news media or otherwise, wouldn't be part of the terms of service. The parties' relationship is governed by the written word itself. So kind of back to Matt's point, that's somewhat cold comfort that a representative of the company is going to make a representation when in fact, the devil's in the details when it comes to these terms of service.
Right. We're going to come back to terms of service a little bit later on in the show, and they're going to keep seeping in throughout the show, I think, in various stories. One place in which they might seep in again is whatever understanding you have with the manufacturer of your automobile, which in addition to the Roomba transporting your cat around the kitchen, your car transports you and your cat and everyone else in your family everywhere and knows a heck of a lot about you based on the telematics and the increasingly complicated and sophisticated telematics that are now standard in any new vehicle. So, Matt, is the Digital Privacy Alliance paying attention to car tech and how car manufacturers are dealing with their management of that data?
This is definitely something that we're looking at. Definitely as the Digital Privacy Alliance grows, you definitely want to be thinking more about it. And there's a huge host of issues here. Coming back to these companies know when you're home, when you're not. These companies know where you go, what you do. And with car telematics, there's a lot of issues around this. For example, let's just say, let's pick a completely innocent case. You want to do Christmas shopping for your family. And all of a sudden now somebody knows where you're going. They might see where you're doing some Christmas shopping for your family. And all of a sudden your family starts seeing ads for something that you've been trying to keep a surprise. Now one can imagine any number of scenarios where it might be a little bit more incriminating than Christmas shopping, whether for good or bad, anything from activism to you were up to no good, but it's not anybody's business but your own. Like you have a right to privacy. And without coming back to terms of service, firm understanding, in a terms of service, a clear understanding by the company that it is now part of your life and you've invited it into your life to share some really close secrets. That's a troubling thing. There's also part of what the Digital Privacy Alliance is concerned with is security. You can't have privacy without security. And as last year's Jeep Cherokee hack shows, there are troubling security issues with car telematics platforms. I know Tesla just released an urgent patch recently. Last year, somebody managed to essentially hack into a Jeep Cherokee and remote drive it. This is an issue. If somebody can get into your car like that, we're not even talking about a database that Chrysler may have. We're talking about somebody being able to hack into your car directly and gain access to internal microphones in the car, listening on conversations, be able to, step on the accelerator when you meant to step on the gas. And in this case, even Jeep wouldn't have any sort of audit trail to have that. It's just between your car and the person who's hacked into it.
Yeah, definitely. One of our listeners actually recommended a book to me a while ago that I listened to, and I think we recommended it once before on the show. I'll recommend it again since we're on the topic. It's called Kill Process by William Hertling. It is all about this. It is fictional, but it seems fairly well researched, and its protagonist, who sort of goes into vigilante mode, does such things where she's, pressing the accelerator remotely in people's cars, etc. So something to wrap your brain around if you're looking for a bit of fiction on this topic. Mike, what do you think about, we know how online terms of service get implemented. When you buy a car, you are given a pile of paper that is rivaled only by the pile of paper that you're given if you lease or purchase a piece of property. Again, terms of service wending their way into all of our stories here. What sort of consumer protection do you think is there for car buyers who want to know that their data is being responsibly managed? I'm sure they are not looking for the clause in their auto purchase contract that deals with this.
Mm-hmm. Now, I mean, this is a vexing problem for that exact reason. And even more so in this context is that, there's a robust secondary market for used vehicles. I mean, how would an owner of a vehicle that's selling it to a new owner, how do you go about disclosing what exact data is being recorded and potentially transmitted? I mean, this is a very, very, very complicated, thorny issue here.
Right. And I don't even know if auto manufacturers make their purchase agreements publicly available. If you're not buying a Cadillac, how are you going to know what's in the Cadillac purchase agreement? It would be nice if we knew that there were privacy and consumer advocates carefully combing through such documentation and finding things like the Roomba clause that got iRobot in trouble recently.
Yeah, I mean, I could envision a scenario for sure whereby individual state laws are passed, as a result of Matt and his efforts. where specific provisions would have to be called out. Like as a purchaser of a vehicle, you'd have to initial a specific terms that disclose the use of data and what data is collected. I recently purchased a new car. I don't remember seeing anything like that. And who knows if I would have really carefully reviewed it anyway. Like a lot of us, it just kind of initial and sign on documents when we're making a big purchase like that. But again, even if that would protect a purchaser of a new vehicle, geez, how do you go about protecting all these folks that are purchasing used vehicles that do similar things in terms of collecting data? I don't know.
Right. All right. Well, a couple more privacy stories before we move on to some more specific Internet of Things stories. If you've been wondering what's up with Kashmir Hill lately, we wanted to bring you an update on something she has researched and published recently. She's been on our show a few times. Wonderful privacy writer in many outlets. Follow her on Twitter. I think she's Cash Hill there, and this was published at Jezebel. She has recently, and like many people who write about privacy, she's not afraid to sort of throw herself under the bus and research on herself, make herself the test subject. And here she's documenting what happened when she began going through the process of trying to get pregnant. Her piece begins, "A month after I ordered prenatal vitamins on Amazon, I started hearing an ad on Spotify that featured the sound of a baby's heartbeat. It was an ad for a prenatal doctor." And so she did a lot of sort of self-guinea pigging of the various pregnancy, fertility kind of apps that are available out there. And she worked hand in hand with a researcher at EFF named Cooper Quinton. They have a white paper that published all their findings, which, I wish I had great news for you that everything was encrypted and secure and not creepy at all. But of course, that's not the result that she arrived at here. What she found, and she was inspired by Princeton professor Janet Vertesi, who did the opposite, went to great lengths to try and keep anything connected to the internet from knowing that she was pregnant, including taking steps like paying for maternity clothes in cash, using Tor to surf baby sites, ordering baby products only to an Amazon locker, and telling her family and friends not to discuss her pregnancy anywhere, even in private texts between them. But, still, that even if you've taken all those steps, I don't know how successful Janet Vertesi was when I was pregnant some 14 years ago. We did not have all the apps available that now people use to track things like fertility and help you get into a childbearing way. But now, with smartphone apps asking you to enter all sorts of data about them, the information that you're sharing is even more intense and detailed than what I experienced. And what I experienced were the kind of things that if you were shopping enough for baby clothes at Target, the things you started receiving in the mail were directly correlated. So definitely that industry pays close attention to who is expecting, because it's a hugely lucrative market. So Cash Hill did this research and documented it, found, as I said, unfortunately, that much of what was being collected from these various apps that she was using, she picked some of the most popular ones and used them on herself, that they found that things were being basically not anywhere, not everywhere, and not always, but in certain instances, things were not secured at all. They were not encrypted. They were subject to being guessed if you simply knew her email address. Various security holes throughout the whole endeavor. Matt, did you take a look, dive deep into this at all?
Yeah, we looked at this, and then we also, there was a recent NPR Illinois piece about featuring a woman choosing to use a German women's health tracking app simply because of the privacy guarantees in Germany, and it wasn't asking for permissions to read all of the data on our phone. Coming back to how, my statement earlier about marketing analytics, on the surface are great. They provide actual real value to people. And coming back to, there's a lot of intelligence that can be used to help people and improve their health. But coming in terms of service, you're inviting a company into your home, into your life, into your body, effectively, with health tracking apps. And there's definitely not a image of respect being shown for that. You invite somebody into your home and they start taking pictures and recording everything going on, and possibly just like open the door for anybody who walks by, who comes in and knocks stuff over and steals things. That's kind of the analogy that we can use for today's tracking world. And I think there's several years ago, there was a case where a woman started getting pregnancy ads from Target after she started shopping around a few things and was outed as pregnant to her family when she wanted to control when and where she discussed that with her family. Coming back to the running theme for today, apparently terms of service, understanding the company's relationship with the consumer, and just securing the data. Because there's a wealth of information out there and you don't know who's getting it.
Right. Go ahead, Mike.
Matt, so in terms of, it sounds like your organization is really all about transparency, which we obviously applaud and think that's very important. Are you advocating for something more than just having it spelled out clearly in terms of service or terms of use that people just click through? Are you asking for broader disclosures in terms of how things appear on a screen or a user's mobile device? Are you advocating or looking at other ways that these disclosures can be made to consumers so they really are informed, as opposed to just being implicitly informed by virtue of the fact that it's buried in terms of service somewhere?
That's a very good question. We're starting off right now looking for transparency with where your data is sent and what broad categories of data is being sent to specific individuals. One of the acts that we are supporting in Illinois, Cook County Sheriff Tom Dart's Illinois Right to Know Act, provides that companies will be able to make available to you once per year what categories of data they have collected and shared with third parties, not in the process of providing you with services, and what third parties they've shared with. So, for example, political affiliation, religious affiliation, sexual orientation, gender identity. These are categories that would be covered and would have to be disclosed. And then we're also supporting a bill for protecting your geolocation information privacy. So everyone carries a GPS tracker on them these days, like modern smartphone, very, very solid GPS tracker. So we are hoping to get require apps to simply tell you when that data is being stored and shared. So taking a larger view of this, like I've said, we don't really have a problem with analytics-based advertising, marketing. It's a better ROI for people looking to sell things, and it's honestly, if ads are being put in front of you for things that you actually want, everyone wins. But we don't know where the data is going. You don't know who's getting access to the data, and with modern information security practice being poor as it is in far too many cases, we aren't confident that the companies storing your data actually know who's all reading your data. There's no way to assure essentially a trust chain between you and the bytes of your data that are sitting on disk, that you can identify everyone who has access to the data along the way. With how security is handled, it could be a commercial hacker sitting halfway around the world reading through the data, much like it could be an advertiser trying to legitimately sell you things. And so we're looking at trying to get better terms of service would be a great start, but easier ways of disclosing this information to consumers easier design language around disclosing information and getting opt-in consent, because we also understand that a series of click-throughs full of legalese doesn't help anyone either. So I suppose the answer to your question in short is yes. But this is a complicated topic with complicated answers to almost every question along the way.
Yeah, and you would think that the corporate financial interests of some of these companies would come into play to rein in some of their activity, some of their enthusiasm to sell you things at all costs. But we see time and time again that the public relations debacle that can ensue, just it either hasn't been sufficiently understood or sufficiently internalized at these companies to make sure that they're not misusing your data or doing something that's going to wind up not just harming you, but getting them in trouble after they harm you as well. Their own self-interests aren't even reining them in. One of the things that Cash Hill highlights in her story is the What to Expect app, which she calls the most obvious privacy offender of the group that she tested. In her own experience, as soon as she signed up for the app, it passed her email address along to a bunch of other companies, including Pottery Barn Kids, Huggies, et cetera, et cetera. Someone else, though, who used the app had a much sadder instance of the kind of privacy leak that you were talking about a moment ago, Matt, about, oopsie, now my kid knows what I got them for the holidays, for example. Here, what the companies, I guess, don't share or sufficiently warn about is when someone's pregnancy terminates without actually having them have a healthy birth. So in this case, a woman named Amy Pittman used the app. She had a miscarriage. And because her email had been passed along and shared with these very eager marketers, she received a congratulatory package in the mail from formula maker Similac a week before she was scheduled to have given birth. Of course, she did not give birth. And, when you're getting things like that, I have a veterinarian who keeps records on an animal that we had years ago and that died years ago and continues to send me a quote unquote happy birthday message for this animal long after its demise. And all it does is make you sad and angry. And I'm sure that poor Amy Pittman had that feeling in spades and worse when she received congratulatory materials for her, in the wake of her miscarriage. So you would think that companies might be able to get this under control for their own self-interest, but apparently they don't. Mike, any thoughts about that?
Geez, I read Cash's article. I thought it was amazing, a real eye-opener. I commend it to everybody. I mean, it struck me as I was reading through. I mean, we're very much in the wild, wild west of data privacy still. There's a lot of great things happening and a lot of great organizations like Matt's that are tackling these very thorny issues. But it still seems like we're very much, I guess not only from a legal perspective, but also from a company economic perspective, we're still very much in the nascent stages of this debate. So.
And
yep, absolutely. Yes.
From the industry perspective, bringing this back to the room at the very bottom of the Gizmodo article, it says big data is big money. There's two very large Silicon Valley firms, one of which had a motto of move fast and break things. Another one, another big famous Silicon Valley firm said always be hustling. The focus is on rapid, massive growth because when you collect venture capital, that's what's expected. They want to see the growth curve go up and to the right, and they really don't care how you get there. So the incentive structure is around playing fast and loose and dealing with issues later and settling a lawsuit, dealing with a PR hassle. That may be just part of costs of doing business.
Yep, you may be right, and that's a sad statement, but a realistic one. We're going to put our first MCLE passphrase into this episode of This Week in Law. We insert these phrases in case you are a lawyer or other professional who likes to listen to or watch our show to get professional credit in your field. If you're a lawyer and you'd like more information about that, head on over to our wiki at wiki.twit.tv. Find the This Week in Law page there, and we've got information about the 50 jurisdictions in the United States where you might be seeking continuing legal education credit. Our first phrase for the show, write these down because sometimes your oversight board might need to know that you watched or listened, and this is one way that we can help you demonstrate that, is happy birthday, you're dead. So we'll try and put another phrase into the show a little bit later on. And right now, since we've been talking about the Internet of Things, let's continue on and play our fun robot bumper. The Digital Privacy Alliance, Matt, does a lot of work around the Internet of Things as we've been discussing. I just wanted to reach out to you here and see if there's anything in particular that you're working on that you wanted to highlight before we talk about some specific stories about Internet of Things devices.
Well, one of the major things that we're working on right now is geolocation information privacy. Your smartphone tracks everything that you do everywhere you go. On iOS, it stores it in a very detailed manner on the device. On Android, it actually uploads it to Google. And so you can actually look up where you've been and what you've been doing for the past amount of history. So we're trying to, that's something that the phones do, and the phones provide very decent services around this. For example, anyone who's gotten a reminder from their phone saying, hey, traffic's running bad right now. For you to get your next appointment, you need to leave in 5 minutes. And that's really cool. However, there's a lot of apps that collect information about you that you're unaware of. There's kids apps that request GPS location data. Why do children's video games need GPS data? I don't know. But they will collect it, and then they'll send and share it, sometimes in plain text. So you might have a unencrypted string of down-to-the-meter accurate geo coordinates for where your child is being sent across the internet. And that's a little creepy and a little weird. And this is something that we've been focusing a lot on recently, and hoping to get, at least in Illinois, moving out across the nation, help to get a bit more control over, to enable consumers to understand that their app collects data on them and allow them to make better informed choices as to where they can, with whom they conduct their business.
Yeah, absolutely. Particularly when we're talking about kids, that's an incredibly important piece to get right. I don't know if Starbucks markets to kids specifically. It probably would tell you that it doesn't. But my son certainly enjoys the occasional Frappuccino. And we are among the folks, I guess, because I have one of their loyalty cards, who will be experiencing its digital flywheel program, which is coming up soon. It is backed by AI, and the AI is attempting to understand their coffee wishes before they've even come up with them. And it's going to keep track of things and make guesses based on what you've ordered in warm weather, what you've ordered in cool weather, what you've ordered at one location versus another. And then it's going to make suggestions to you as to what it thinks you might want to purchase. It will vary those suggestions based on the day of the week, whether it's a holiday. If it's your birthday, it's going to offer you personalized selections. So here we have a loyalty program working with an app, working then with AI that is all trying to make your experience better. But are you concerned about the data and how it might be managed and what sort of consents are going to be gathered about use of the data, Matt?
Mm-hmm.
Thought you would be.
Yeah, definitely. every rewards program, frequent buyer card at the supermarket, Starbucks Rewards is a marketing program so that they can positively assert an identity with a purchase. And that is by definition an opt-in system. And a lot of time, as we're seeing here with Starbucks Rewards, they give you bonuses so they can better track, identity to marketing programs. And in that vein, if they keep the data there, and if they keep the data to themselves and secure it properly, I don't necessarily see a problem with this. You don't have to give up coffee if you opt out of the rewards program. You're not missing out on anything except maybe rewards, but that's the carrot to get you into the program. If they're responsible with it, if the terms of service, coming back to apparently this week's theme, that's not necessarily troubling. They need to make it upfront clear as to what they're doing. They need to let you know that they're tracking where you're going and what you're doing in terms of additional data they're collecting beyond just what you purchase and when. Because obviously, you think with the rewards program, you start with the data that's available at the point of sale system. So who you are, what you've purchased, what location, what time of day. If there's additional data being collected by the app, then yes, you ought to be able to opt into that. And they can make the rewards program in general conditional on that. Like I said, just amount of coffee. But otherwise, I think it's a well-structured, on the surface, without diving too much into what they're doing with the data. But just giving them the benefit of the doubt, as long as they're not sharing that data otherwise, as long as they're not, and as long as they have it secured, nothing comes to my memory right now about the great Starbucks data breach of whatever. So as long as they're responsible with it and responsible with you, the consumer, who is keeping them in business by buying their coffee, then I think this might actually be a decent example of how analytics and big data combined with positive, affirmative consumer opt-in can work towards everyone winning. Starbucks gets to sell you more, you get more coffee.
Right. And since many of our stories this week are sort of the creep you out, scare you to death variety, we wanted to do some fake news busting about a supposedly creepy AI story that turned out to be not quite so creepy that happened while we were on our break. And that was the story about the Facebook AI that made up, that quote unquote made up a language and started talking to itself or its AI components in ways that its programmers could not understand. People viewed this as the harbinger of Skynet. And it turns out that no, that's not actually what was going on here, that the bots, as bots are programmed to do, started chatting back and forth in a shorthand that they created, but it was not really a language, and certainly they were not plotting the downfall of humanity. And although Facebook pulled the cord on the system, that is not because it was afraid it had stumbled onto an existential threat to mankind, as the BBC puts it. But no, they just were not interested in studying that aspect of the chat's development. So that's how the BBC is putting it, and I'm choosing to believe them. What do you think, Mike?
Well, glad to know we're all not going to be terminated sometime soon. So
yes,
yeah, it's funny read.
Yes, it was, and hopefully you're not still just wringing your hands over Facebook's rogue AI. Any different take on this that you might want to offer us, Matt?
Not particularly on this story. A bunch of bots that have developed their own language is kind of interesting, and I mean, in their own shorthand that the AIs developed with each other, they might have been plotting human downfall. Who knows? But for the moment, we haven't given the AI control over its own power cord yet, so that's fine. Yes. There's larger issues at play with AIs and their use in digital media, digital marketing, decision making that we have. But in Facebook, doing weird AI experiments with all their computing power. As long as they hold on to the power cord, I'm okay with it.
Right. That sounds like a bad sci-fi movie plot right there. You pull the plug and it's still working. All right. On that note, let us move on. We've been talking about terms of service all show, but let's talk about some specific terms of service stories. This is one that we could not let go, even though it happened, while we were off on break a couple of weeks ago. I'm sure that people listening have already heard the story and laughed at the story, but we'd like to laugh at it too. And that is the one about a Manchester, UK-based company called Purple that specializes in running Wi-Fi hotspots for commercial outlets. It decided to conduct an experiment. It hid basically an Easter egg in its terms of service and offered a reward for a prize for anyone that found it and went to Purple and said, yeah, we found you out. Only one person, sadly, found this in its terms of service. I am unaware of what the prize was, but I hope it was a good one. And what they hid in their terms of service is that in exchange for using the Wi-Fi at these various locations, the users then had to, at the company's discretion, cleanse local parks of animal waste, provide hugs to stray cats and dogs, manually relieve sewer blockages, clean portable lavatories at local festivals and events, paint snail shells to brighten up their existence, and scrape chewing gum off the streets. 22,000 people actually clicked OK on those terms. And although, as Gizmodo reports, it's unclear if Purple would even be legally allowed to enforce the clause. And thankfully, Purple has said that it won't even try. Purple's motivations for doing this were actually partially privacy-oriented. It was a campaign to raise awareness about needing to read terms of service, as we hope that we are also doing here today. And it also was designed to draw attention to Purple as the first Wi-Fi provider compliant with the GDPR, the General Data Protection Regulation that will go into effect in Europe next year. So good on you, Purple. Good way to bring attention to at least one very important issue, and your company and its compliance with the GDPR. So, Mike, what do you think? Would they be able to make you hug a stray dog or cat?
No, I would not be doing that under any circumstances. They'd have to, take me to court, throw me in jail, do something. I don't know. But no, I will not be hugging a stray dog or cat anytime soon. This story is both, hilarious and disturbing, I guess, at the same time. Mm-hmm. But it also made me wonder, okay, so you've got 22,000 people that apparently clicked through and agreed to these terms. I wonder if, we know that at least one person read them and ultimately claimed the prize. I wonder how many people read them and still thought, what the heck, I'm just going to do it anyway, without really questioning, what these terms of service are all about. Maybe they didn't give it much mind, but it was interesting to think about, okay, well, even if something is disclosed to a consumer and consumers are made aware of what's going on here, does this show that, consumers don't care? They just want to ultimately get to use the internet service or get the product or service that they really want. Interesting to think about human psychology associated with this story.
I like it. So your theory, if I'm hearing you correctly, is that possibly all of these 22,000 people, or maybe just some of them, were actually very civic-minded and possibly accepted these terms and were down with manually cleaning the sewer, perhaps?
Well, I don't know about that, but I do think that I would think that some people may have read through these terms, maybe more than just one, and maybe they saw them and thought, oh well, this is a joke, or even if they, what are my chances that I'm going to have to actually do this? I don't care. I'm just going to sign up for the service. So
right.
But I suppose your theory is equally as valid. Maybe there's some very civic-minded people that said, hey, of course I'm just doing my part in scraping gum off the street or petting a stray dog. I don't know.
Yes, I'm quite good at painting snail shells when put to the task. What do you think, Matt? Which of these would you be out there slaving away at?
Well, after a accident involving a window in high school, I spent 6 weeks scraping gum off the bottom of cafeteria tables. So
you have experience.
I can attest that that's not a very fun thing to do, but I think I know plenty of people who would love to be required to give hugs to animals.
Yes.
But I think at a larger view that this really illustrates that while terms of service is a great start because it does define legally the relationship between you and a provider, it's not all that we need to ensure that there's good consumer protections on what's happening with somebody's information.
Yeah.
Yeah, and I do like the fact that a company took it upon itself not to hoover up everybody's data, but to bring awareness to this issue. So if you are in charge of implementing communications policy or legal policy at a company, consider doing something like this. I think it's a great thing to do. All right, we're going to turn now to some developments in legislation, regulation, and policy. So we know, because we've been talking about it throughout the show here, Matt, that the Digital Privacy Alliance has various pieces of legislation that it is hoping that states, Illinois in particular, and various other states will enact in order to protect the privacy rights of their citizens. You've highlighted a few. Is there anything more that we should touch on here at the state level that's going on that you'd like our listeners and viewers to know about?
Well, there's a company that we partnered up with, Data Foundry, and they're in Austin, Texas. And they actually, for anyone in Texas interested in what's going on, they run very good scorecards of what's going on at the Texas level in the State House. And that's, we're looking to expand out scorecards to Illinois and across the country to keep a kind of a dashboard of ongoing privacy impacting legislation. But as a start, I would really recommend taking a look at them for what's going on in Texas. And recently, to make it a little bit more hyper-local, we recently spoke in front of the Chicago City Council to support geolocation privacy as a municipal ordinance in Chicago specifically. So that's right now where we're sitting at, and we're just about to really sit down and focus on where we're going and start being able to provide more guidance to legislators and help in the future, especially running into 2018. We've got our eyes on the long game here.
Great. That's good to know. A couple of non-Illinois, non-Texas pieces of legislation that we've got our eyes on. One is at the federal level, and this is legislation that would reform the Electronic Communications Privacy Act. It is called the ECPA Modernization Act of 2017. The EFF and others are supporting this bill. And we are hoping, too, that the ECPA, Electronic Communications Privacy Act, gets an update. I think it was enacted in 1986. So it definitely could use some help to bring it up to speed with the habits and uses of both companies and their users. As EFF points out, they had a good quote here that talked about most people not understanding that an email stored on a Google or Microsoft server has less protection as far as whether a warrant is needed to get at it or not, for example, than a letter sitting in a desk drawer at home. And that's one of the things that this ECPA Modernization Act is designed to address. It also is concerned with tracking, like we've been discussing all show with you, Matt, and various other aspects of bringing this law into the modern age. I take it you would like to see this passed?
I would love to see this passed. Mm-hmm. For example, you touched on email. ECPA defines email after a certain amount of time as essentially abandoned. And in 86, that made sense because if your email was sitting on a server for more than 30 days, a small email still took up, at that time, a significant amount of disk space on the machine. And you would to read email, you download it to your own local computer before reading it, and you would delete it off the server to save space. You might have like 2 megabytes of storage at that. In today's world with multi-gigabyte inboxes, you leave it on the server and it bounces between various devices. So the very nature of how email works is completely upside down compared to the world that ECPA was written against. And we're also seeing on top of this, law enforcement trying to use private information as end runs around warrants. And while the updates that we just discussed to ECPA aren't everything, but a great step in the right direction.
Right. And then in California, which also does a great job of enacting privacy rules that then other states have to follow because just about everybody does business in the state of California. California has a bill pending that's got a long and winding road ahead of it. It is called Assembly Bill 375. And what it aims to do is reinstate the FCC privacy requirements on ISPs that were undone earlier this year. So it would require ISPs to have your opt-in consent before sharing data that the ISPs are able to gather about you, including browsing history, with third parties. So California is aiming to enact its own legislation that would do that. It looks like it has a hard road ahead of it. There are various procedural ways that it can get knocked out before it even passes committee and gets to consideration before the full California Senate. And then assuming it clears all those procedural hurdles, there's no guarantee that it would necessarily pass. But as let's see, I think this is The Verge reporting on this. They had a good observation and right. The law has not kept pace with advances in technology. Nope, I'm reading the wrong quote. 1 second. Illinois, New York, and several other states are now considering bills that would provide the FCC protections, either by introducing entirely new privacy measures or by amending existing legislation. So far, the majority of those measures are still under consideration, but California is facing a major trial in coming days as state Senate committees debate Assembly Bill 375, a measure that could be a bellwether for similar debates in other states. And the reporter at The Verge goes on to note, this is a really popular consumer issue, a bipartisan consumer issue, and how this goes in California could be telling for other states. If the lawmakers are able to sort of quietly make it go away, it's not really their problem. So I think they have the opportunity to make this win-win for the lawmakers, but not necessarily win-win for consumers. If it passes, they get to take credit for it. If it goes away, maybe other states will follow suit. And the lawmakers will say, well, we didn't really have a backlash for failing to pass that, so maybe we don't need to take similar steps. Matt, what do you think about the California legislation?
I'm in favor of all the states' efforts to enact that tougher FCC regulation at the state level. And advocating for laws in Illinois, I definitely understand the hurdles that laws face. There's significant amounts of money being spent on lawmakers' reelection campaigns and definite lobbying. There's really large amounts of money being spent on killing privacy bills at the state level. That groups like the Digital Privacy Alliance, which is director funded and all volunteer time, and this is what we're pushing back with. The thing to keep in mind with ISP protections versus service protection. So you have online services such as Google, you have Facebook, Microsoft, and then you have ISPs like AT&T, Comcast, etc., Verizon, groups like that. The big difference here is that online services, it's a lot easier to shop for. Once you get onto the internet in general, you can run your own email server. You can use different providers. You can use Proton Mail in Switzerland for your email if you're feeling paranoid. There's free market choice in deciding where you where you do business. However, ISPs, the better analogy in this case is your roads. You can go to different supermarkets to do your shopping, but you need your roads to get there. And ISPs are the roads. And in many places across the United States, there's only one ISP in town. And even, for example, in Chicago, there's basically two ISPs with another third small player available within a certain distance of various landmarks of the city. And if your ISPs aren't respecting you, aren't respecting your privacy, to get online, there's no other choice. And as there's more pushes towards e-government initiatives, as there's electronic learning, work from home. For example, I'm broadcasting out of my home office right now. Access to government education and jobs is impacted by how ISPs handle you and your data, and you can't decide to just not use the internet if you don't like the ISP choices immediately around. So given that it's not as much of a free market competition choice, we definitely support the stricter controls on ISP privacy guidelines.
Right. All right, one more legislation and policy story, and I think we will get into our concluding material of the show after that. But I would feel remiss were we not to discuss one other development at DEF CON, and that was the hacking of the voting machines, which hackers were able to get control of within minutes in some instances. I thought this was a really fascinating development at DEF CON. There are some caveats here to bear in mind if you've heard that various voting machines were hacked and pwned and basically taken over and made to be the BITCH of the hackers at DEF CON, it's not as bad as you might think. None of the machines that were hacked are actually actively in service. In fact, they bought a bunch of machines from government surplus via eBay. So they're machines that were in use. And you could, definitely draw conclusions about the fact that various voting mechanisms in the United States were using these very machines before they were decided to be resold on the aftermarket. So they're maybe not being used in today's elections, and hopefully the lessons that are being learned here can be applied to the machines that are being used in today's election. The Register wrote up this story from DEF CON, and they say, think of it as a wake-up call. One thing that, before we get into being able to actually manipulate votes, from the privacy front, one thing for governments to pay attention to and treat as a wake-up call here is that the machines weren't wiped of data before they were sold to third parties. There were some 650,000 voter personal records still there on them, and hackers were able to go ahead and access those records. And also, in one instance, they found administrative passwords for the machines via Google in I think more than one instance, and rickrolled at least one voting machine. So if the next time your voting never going to give you up comes on the screen, you might be cued into the fact that your machine has been compromised. But as far as being able to actually manipulate votes with these machines, I think the hackers demonstrated that could be done. So this is right up your alley, Matt. I'm sure that you were paying attention to this as it unfolded.
This is actually what I studied in college as well. Political science degree from U of I in Champaign, and I spent a lot of time studying the actual mechanics of casting votes. And even back then, in the 2000 election, the biggest issues with vote discrepancies were electronic machines. And Diebold had a major leak where they just put source code and software and election data on an open FTP site for anyone to download. And it's just gotten worse, honestly. I have no doubt that existing machines are just as bad. And when you're talking about manipulating elections, these are very valuable hacks against systems that have old vulnerabilities. So you might have somebody who keeps a few in their back pocket. Sure, DEF CON had a lot of hacks happen very quickly. There might be vulnerabilities known as 0 days, where it's a hack that isn't publicly known, that isn't being made around the security researcher field. Somebody has in their back pocket and can sell or use at an opportune time, or to make a good amount of money for somebody else to use it at an opportune time. When we're talking about elections, you need transparency in every step along the way. And with voting machines, electronic voting machines, you cannot verify the hardware, you can't verify the software as you're about to vote. You have the same issues with influence that paper ballots have. There's so much focus on hanging chads, but when you see the issues with electronic voting machines, it's just a catastrophe, in my opinion. For the past decade and a half, I've been in favor of nothing but hand counted paper ballots, precisely because of issues like this.
I'll pass that on to my 13-year-old who cannot wrap his head around the fact that we still vote with paper ballots in today's day and age. There are good reasons for it, and we're talking about them right now. Mike, did you have anything to add on this front?
Not really, other than when I was reading it, I was kind of thankful for the fact that we actually are mail-in voters here in Washington. We vote on paper. So, it's this is not fake news. I mean, this was really kind of frightening and scary, and you can see why, James Comey had commented that the Russians, they'll be back at the next election. I mean, this would obviously be fertile ground for anybody that wanted to mess around with the democratic process here. So it's scary stuff.
It is. And, if we're going to talk about legislation, regulation, and policy, this is how it gets made from our elected officials, and being able to know that they were elected in the way that reflects the actual wishes of the electorate. So good on DEF CON and the, what was it called there? It was called the Voting Village, the first ever voting village at DEF CON, where people got together to expose these vulnerabilities and let people know that these voting machines are still not ready for prime time and widespread use without a whole lot more attention paid to their security. So we'll make Hack the Vote our second MCLE passphrase for this episode of This Week in Law. We have, as usual, an animal selfie of the week for you. Let's go right to it as sort of a unicorn chaser to all of the scary, dire things that we've been discussing today. This week, we bring you an eagle. like to think we soar with the Eagles here at This Week in Law, and you can too, thanks to our animal selfie of the week. And thanks to the theft of a GoPro camera by one of the world's great raptors.
Ooh.
Here we go. What I love the most about this footage, and for those of you keeping track of our animal selfies and the various legal ramifications of the video or photo being taken, here we have the eagle as cinematographer. I love the creative addition of the talon in the shot.
It's beautiful.
And we have the selfie. You see the eagle actually getting its face in there as well. So it hits on all fronts. And I'm sure PETA is writing briefs as we speak. Moving on, we have a few resources of the week for you. Something for you to, do in your own privacy educational time. It is a video of about 8 minutes in length from PBS, and it is entitled "Online Privacy: How Did We Get Here?" It's sort of a history of online privacy and the state of it, how we think about it, what sort of regulation we've had around it, how people's attitudes have shifted over the years. It's definitely worth watching. We're not going to show it to you here today in the interest of time and brevity, but I do recommend it. It's from PBS Digital Studios. Two other things you can check out that I found interesting, not having to do with the privacy front, but we talk about entertainment and copyright here quite a bit. Over at Music Radar, they have a list that they call the Giants of Sampling, legends that changed the course of music through sampling. And they include such greats as the Beatles and Pink Floyd and various others you might not have heard of before, such as Pierre Schaeffer, who they say could quite comfortably be classified as the godfather of sampling. So if you're interested in music and sampling and how people have evolved that over the years, this Giants of Sampling piece is pretty cool and interesting. And then finally, just to entertain, is a piece featuring an artist, an anonymous artist. We can't give them credit. We don't know who did it. But what they did was they took classic children's books and photoshopped new titles in, creating a really wonderful bit of remix art. The Sweet Valley Twins, which I'd never heard of before, with such titles as "I Want This Date to End So Badly," with the young man and woman looking at each other. Poor grandson doesn't want to talk to grandpa because grandpa voted for Trump, says the hacked or remixed title, I should say. Various not so safe for work ones in here, so beware. But really cute, interesting reuse of classic book covers. And then finally, our tip of the week has to do with something that the Digital Privacy Alliance is seeking to enact legislation about, basically securing the microphones in various devices in your home. Ars Technica, Dan Gooden over there, has a piece on how a hacked Amazon Echo could take over the microphone and start using it to your detriment, against your will, and without even having Amazon involved in the equation. This is a hack that enabled someone to surreptitiously capture the raw microphone input and send it to an attacker-controlled computer. And it relies on something called the Evil Maid. Tell us about the Evil Maid, Matt.
So the Evil Maid attack is simply somebody who you trust with access to your home, but don't actually know very well or could otherwise be influenced, who has access to sensitive hardware. In this case, it's an Amazon Echo. There's several cases where you could say somebody could slip in, plug a USB key into your computer, reboot it, install some malicious firmware that sends keystrokes and other data back to an attacker-controlled machine, or any number of attacks based on direct physical access to hardware. This is just one example here, but this is if you have sensitive data that is worth attacking and is worth paying off a maid or a janitor or a silent break-in job, or a lover who may not be feeling so loved. This is something that's existed for a while and will forever continue to exist as long as computers are physical objects.
Right. So I guess our tip about this is beware the evil maid. Be careful who you're letting have access to these devices. The overarching tip would be hopefully for device manufacturers to plug holes that allow these kinds of hacks to take place. Also that this particular technique doesn't work on the Amazon Dot. So if you are choosing between your Echo devices, that one is more secure from this attack than the other Echoes. So interesting stuff, and be aware. All right. Thank you so much, Matt. It's been a pleasure to meet you. Matt Erickson, Vice President of Engineering at Spider Oak and Director of Industry Outreach at the Digital Privacy Alliance. It's been great chatting with you today.
Thank you. It's been great to be here.
Any last things you want to tell our listeners or viewers about before we go ahead and sign off with you today? Any events that the Digital Privacy Alliance is involved in? Any way they can support the organization?
Yeah, definitely. First, we have an open letter to Governor Rauner to sign the geolocation bill into law. Also, we've touched a lot on terms of service, treating customers with respect. If you're working with a client, or if you are somebody directly working on how to shape a interaction between a company and its user base, and want to make sure that you're actually respecting your customers as opposed to just covering your butts for the company, we are very happy to help with that. While we are definitely pushing for legislation, what we really want to see is simply good and honest respect between service providers, companies, and their customers. So if you need a hand with it, if you need somebody to bounce ideas off of, or just help thinking through something, we are definitely here to help. And we're very happy. Just shoot us a line.
That's great. Thank you so much for your time today and your insights. It's been really nice meeting you.
Thank you.
Mike Keys, great to see you again. Mike, of course, is a partner at the Dorsey & Whitney firm in Seattle, Washington. Great to reconnect with you after a couple of weeks' absence. Anything going on with you that we should know about?
Oh, well, we're just enjoying the final waning days of summer here. Kids will be back to school in a few weeks. So we're going to try to sneak over to Montana and have some fun there for a few days, and then we'll be back at it. So great to see you, and it was great to be with Matt.
It was. And for those of you wondering, what happened to Matt Curtis? He was going to come in halfway through the show. I haven't checked my email, but apparently he got caught up and couldn't do so. So hopefully we'll see Matt Curtis next week again. Emery Rohn is going to be back on the show as soon as he can be, hopefully in September or October sometime. He has finished and survived the bar exam for everyone who was concerned about Emery's health and well-being. Yay, he's doing great. We'll get him back on to tell you more about the harrowing experience of the California bar and what's going on with him, hopefully in recent weeks. We record the show every Friday at 11 o'clock Pacific time, 1800 UTC. We hope you can join us live, but if you can't, don't worry. Just head on over to twit.tv/TWiL. Our whole archive of shows is there for you to enjoy at your leisure on the hopefully very, very secure device of your choice that is not bleeding out your information and geolocation to the world at large. But if it is, we'll at least have talked about it here. So you can definitely check out our shows whenever, however you can. We just are super glad that you do. We hope that you'll get in touch with us between the shows. Mike is Mike at twit.tv. I am Denise at twit.tv. Matt is Matt C, I believe, at twit.tv. And so that's a great way to shoot us an email. Let us know if you have follow-up thoughts on things we've discussed, things you think we should see, guests you think we should have on the show. We love hearing from you. We're on Twitter and Facebook as well if you want to find us there. All great places to get in touch. Thank you so much for doing that and for joining us today here at This Week in Law. Until next time, take care.